Well, good afternoon, everyone, and welcome to the Justice Subcommittee in Policing. This is our 11th meeting of 2019, and we have no apologies. Now, just perhaps before we start, I'd like to make some brief comments about the resignation of the SPA chair. And members will be aware the resignation this morning of Susan Deakin as chair of the Scottish Police Authority. And I'm sure all members will want to thank Susan for her service and wish her well in any future endeavours. We also note her comments on governance and scrutiny of policing, which will be issues for the Justice Committee and the Justice Subcommittee on Policing. And I'm sure we'll return to these issues in the new year and consider what further work, if any, is required. Now, item 1 on our agenda, a decision to take in business in private, and it's items 4 and 5. A discussion on our work programme. Are members agreed?
Agreed.
Thank you very much indeed. Now, item 2, facial recognition, how policing in Scotland makes use of this technology. And it's our inquiry, and I refer members to paper 1, which is a note by the clerk, paper 2, which is a private paper, and paper 3, which is a written submission by Dr. Nina Miranda of Northumbria. And I welcome the witnesses to today's meeting, Dr. Ken MacDonald, Head of ICO Regions, Information Commissioner's Office, Griff Ferris, Legal and Policy Officer, Big Brother Watch, Matthew Rice, Scotland Director, Open Rights Group, and Tatora Mukushi, Legal Officer, Scottish Human Rights Commission. You're all very welcome, and I thank you for your written submissions, which, as ever, are very helpful to the committee. And we'll move to questions, and I have the first question for you, panel, and it's about the concerns that have been expressed in the papers about the lack of an explicit legal basis with regard to the taking and retention of police custody images by Police Scotland. Would you like to comment on that, please?
Yeah, I'd be happy to open up. So Open Rights Group have been concerned about this situation for a few years now. It was brought to our and the public's attention via the Independent Advisory Group on the use of biometrics in policing, which had, as part of their recommendations, had suggested the creation of a Scottish Biometrics Commissioner. Alongside that, they had pointed out that under the Criminal Procedure Scotland Act 1995, there is no explicit reference to photography or facial images that were taken. There are other types of descriptions of materials to be removed from an individual, but specifically referring to facial images, it has not been captured. A separate point as well has been the legacy systems that were in place by Police Scotland meant that some of those images that were captured were also retained for longer than, say, DNA or other biometric material, which is an additional consideration. And I think it's aligned to the fact that there wasn't a clear statutory or legal underpinning for the collection of those images in the first place that has led to this divergent practice between DNA, which has quite clear retention and deletion periods, and the custody image situation that we're in currently.
Dr. MacDonald, thank you.
I mean, we understand the concerns that Matthew has expressed there. We also understand that there are major issues with legacy systems which were designed a long time ago, which weren't built in the way that systems are now required to by law under the GDPR and the DPA 18 by having privacy by design built in. There was implicitly a requirement to take these into consideration under the previous legislation. There's an absolute explicit requirement under the new legislation. We do know that the police authorities are looking at ways in which to handle these images more appropriately. But in terms of the legacy systems, I think we have to take a pragmatic view that wholesale deletion is not necessarily in the best public interest, but we are aware, obviously, that there are risks to the rights and freedoms of individuals who have not been found guilty, but whose images, unfortunately, are retained because of technical issues. We certainly think that any legislative measures which clarify retention and disposal periods should always be welcomed.
I wonder, is there somewhere between that, though, between wholesale deletion and deletion of those images which might be perceived as not being legitimately held? or having a legal basis for their retention?
I think the problem is that the systems, the previous systems were set up in a way which deletion is proving problematical, and hence it's either all or none. But I would have to check up on that.
Okay.
Yes. Matthew has summed up the legal position very well. I think I'd only add that the position in England and Wales is very similar, and because there's an overlap between Police Scotland and other police forces in England and Wales, in as much as they upload images to the Police National Database. Police Scotland has said that they estimate they hold around 1 million images on their databases. Police forces across the UK and in England and Wales in totals around 21 million images. These are huge figures of images that are held, and there's, for what it's worth, the same position in England and Wales with regards to a system which was built which wasn't able or wasn't capable to delete images of unconvicted individuals after their status had either been finalised as not convicted or they weren't even charged following arrest. So there's a similar position, and the Home Office has said that they, due to technical issues, cannot implement a deletion of these legacy images, although they are currently reviewing all of the images that they hold, we understand, to decide whether or not they can delete those images.
Thank you. Mr. McCushy.
Yes, good afternoon, Mr. Finney. From a human rights perspective, I think the proportionality of using such large databases of unconvicted or untried individuals is problematic. It certainly engages Article 8. And if you're, while we can appreciate the practical difficulties and the technical difficulties there are involved in seeding or sorting out these databases, the issue will arise in cases of current justice. It'll become an Article 6 issue if the presumption against deletion comes into place and the police are still relying on these databases that are full of things that really should have been deleted. It's unfortunate that the systems weren't designed more forward-thinking or with privacy in mind. However, looking forward, the police will be faced with a stark choice. They may simply have to forego using what they have and start in a way that is human rights compliant, because the impact of using these unreliable systems would be quite severe and disproportionate.
Thank you. Have any of the panel in a position to say, and I'm not remotely technically minded, but to say if, notwithstanding that these images are inappropriately held or illegally held, can they be utilised and can they be scanned, can they be searched? Or is it...
Ultimately, as I understand it, it depends very much on the quality of the images taken. So for some of the technologies that we were to discuss as we move further into the hearing, they do require a certain level of kind of fidelity and resolution that would allow them to be read. So the question that isn't necessarily clear, because often when you ask Police Scotland...
Sorry for the avoidance, I should have clarified. I'm meaning custody images that are...
Yes, exactly. So I'm not sure the resolution of custody images specifically to say, yes, these could be added to any of the technologies or data sets that we may be discussing later. So it all depends on the resolution and the quality of the image taken. As I understand it, I would expect that some of them would be of some, if they're a custody image of an individual that is taken during booking or arrest, that they would have some level of quality attached to them that could be utilised. But it really depends on that answer from Police Scotland about how good the images really are, as to whether or not they could be used in any of these systems.
Okay, thank you. There might be a view that, and we are moving on to live facial recognition, that introducing a new system when we've been able to resolve the existing problems with a previous system is foolhardy. Do members the panel have a view on that?
Yes, I mean, that's been one of our major concerns, is that police in England and Wales have implemented live facial recognition technology which utilises custody images which are from a database upon which there are known to be hundreds of thousands of innocent, unconvicted people on that database, and that's been one of our major concerns around the use of live facial recognition. There was a legal case in 2012 in the English and Welsh courts which held that the indefinite retention of custody images of unconvicted individuals was unlawful. To date, they have not been removed, and arguably that judgment has not been carried out by the Home Office. There have been a number of reviews. There is a review ongoing at the moment, but there hasn't been the requisite action, and so ultimately these unconvicted individuals' images are still held on the databases. Figures are as high as 21 million images on the database as a whole, and 12 million of those have been made searchable by facial biometrics. So those images can be searched using facial biometric technology.
Mr. McCushie, you referred to the Articles 6 and 8 there. Is it likely that were any of these images to be used, images that are illegally held or for which there's no legal basis for their retention, would that be the subject of legal challenge, would you imagine?
I would imagine, certainly on Article 6 perspective, and I probably should explain the Article 6 being the right to a fair trial and the right to due process. If it was known that the police had used faulty or unlawfully held images in identifying suspects or in any part of the investigation, then the investigation is then suspect itself. Now in Scotland, and forgive me, I don't practice criminal law this side of the border, in Scotland there is, as far as I'm aware, a fairness balancing exercise to be made, firstly by the Crown Office in bringing charges, and then obviously by the court to determine whether or not the evidence pool is contaminated by such an act. So if it was the case that it was found to be something that shouldn't have been in the database in the first place, and there'll be arguments around that, I think it could certainly be subject to challenge and possibly successful challenge, and it's something that the police should bear in mind.
Thank you. Can I, sorry, Mr. Ferris.
Just add, the Biometrics Commissioner in England and Wales has said publicly that he does not believe that it would stand up to a legal challenge if it was challenged.
Okay, thank you. Can I move on to, witnesses will be aware of the court case in Wales that recently refused an application for judicial review with regard to the use of live facial recognition and the ruling that the technology was lawful. I wonder if the witness have any concern about that judgment with regard to human rights and data protection. And I think I've touched on this with Mr. Makushu there. Any expectation, if that were to be employed, that technology were to be employed in Scotland, that there would be challenges on both these fronts? So that's on the human rights and the data protection front.
The Commissioner, as you're aware, has issued an opinion on the use of live facial recognition technology, and that was subsequent to the South Wales Police Bridges case. The issue there, I mean, the court found that it would be lawful, bearing in mind all the other restrictions that there are in place, such as the Data Protection Act. And our view is that that was that specific case and that can't be applied in as a general framework. As you'll have seen, I think we can emphasise the importance that the Commissioner gives to this, as this is actually the first opinion that she has written. It's a new power under the GDPR, which came into effect last year. And this is the very first one. So I think you can see that it's high on her priority. Her view is that we should look at each and every use of the technology on an individual basis, that a clear case has to be made for that. It has to be recorded as is required under the new Data Protection Act in terms of the appropriate use policy. Excuse me. Every single case should be looked at separately. A DPIA, a data protection impact assessment, should be made. It should be focused, it should be narrowed down. The arguments for the precise use of it have to be clear, understandable, and made clear to the public as it goes on. So the judgment is there. We have to build on that. But I think, as is implied through the opinion and her references to the Surveillance Camera Commissioner, which obviously doesn't have jurisdiction up here, I think anything which is clarifies where we in Scotland would like to see the use and how we would like to see the technology being employed would be very helpful.
Mr. Ferris.
There are a number of very serious concerns with this technology, and I think if it was to be implemented by Police Scotland, it's very likely that it would be subject to a legal challenge. There's obviously the challenge against South Wales Police. We have brought a challenge against the Metropolitan Police and the Home Secretary on similar grounds as the case in South Wales. We're currently stayed, and we hope to proceed as soon as the Metropolitan Police decide whether or not to roll out this technology on an operational and full-time basis. But I wouldn't be surprised at all if Police Scotland were to implement this technology, that there would be or could be a challenge under human rights. It is a very serious threat to, as has been mentioned, the right to privacy, the right to freedom of expression and association, and there are very serious concerns around its discriminatory use as well, notwithstanding its general complete ineffectiveness as a technology.
Thank you. Do other panel members have a comment?
Other than to reiterate, as Ken MacDonald pointed out, that the Bridges judgment really was quite narrowly based on the facts that were available, and each of those deployments were scrutinised, rather than saying this is a green light for facial recognition at a large or general scale. And echoing Griff's points around that the scope of intrusion that facial recognition would involve would make it likely for challenge, I think, in Scotland.
Thank you. Mr. McCushon.
The only thing I would add is to points to the conversation that has been in Scotland about the Scottish Biometrics Commissioner, sort of very wholesale consultation with experts and public alike, and the pretty universal agreement that there should be a code of practice in place for dealing with biometrics, and that should probably be a precursor to the introduction of these technologies. And the independent advisory group that produced the draft code of practice, they pointed to facial recognition as being uniquely problematic at the moment because of the lack of efficacy, lack of evidence of its usefulness, and to proceed without that, without something that's been signalled by the Scottish Government or the Cabinet Secretary, by the Police themselves, that they would welcome, would be extremely problematic to begin rolling that technology out without bearing those things in mind.
Okay, thank you very much. Yes, Dr. MacDonald.
That, in terms of the processing, and there's two options for the police in operating this. One is consent. And I say that as an option, as in the sense that it's in the law, but it's actually a totally impractical condition for processing when you're going out into public space. The other part is that it is strictly necessary for the purposes, and strictly necessary is a very, very high bar. And they would have to demonstrate clearly why it was appropriate to use the facial recognition technology when they were deploying it, and why other forms of policing methods couldn't be employed to get the same result.
Okay, thank you. That's very helpful. Liam.
That is indeed very helpful. Good afternoon. I was going to touch on the issue not just of necessity but proportionality as well, and I just wonder what the panel's views are on the extent to which those principles have been taken into consideration in the trialling of this technology to date, and a balancing, I suppose, of what we're really talking about, which is the cost to individual liberty as compared to the proposed public benefits in terms of public safety. I take it Mr. Ferris, given the legal challenges, not at all convinced would be the response, but I wonder if you go in more detail.
From the start of our investigations into the use of this technology, as early as the beginning of last year, when we were trying to attempt to uncover the way it was being used, how it was being used, often using freedom of information requests, our own legal analysis and then independent legal analysis from our counsel suggested very much so that it was not, the way it was being used was not necessary or proportionate under an analysis of Article 8, the right to privacy, and the right to freedom of expression. We've seen it being used against people who haven't committed any crimes at all, people who are merely on watch lists for having mental health problems. We've seen it being used at a political protest, which engages, obviously other very serious concerns around a chilling effect of being able to demonstrate your political views or beliefs. So there certainly hasn't been any due attention paid to that high bar that is needed when it comes to necessity and proportionality. It hasn't been used just, for example, to target serious or violent crime. There's been the indiscriminate scanning of thousands, hundreds of thousands. I think the case in South Wales stated that an estimated 500,000 people had been scanned, and they've made, I think, just around 30 plus arrests in that time. They've deployed around, I think, just over 50 times. So, given those numbers, the number of people who've been scanned by this technology, who've had their personal biometrics taken, which are akin to fingerprints or DNA, that's the scale of privacy intrusion that this technology has. And I guess it has to be weighed up as to whether making that small number of arrests is proportionate to that intrusion.
Does that, again, a little like the convener, I'm no technical expert on this. Does that kind of suggest the way in which the technology operates means that the already high bar of necessity or proportionality is unlikely to ever be met, given the extent to which it's capturing images well beyond those who may be the target of the process?
It's very much our view that because of that indiscriminate nature of this technology, that it scans everybody within view, that it does so without their consent, not in a necessarily a legal sense, but also in a legal sense, but also potentially without their knowledge, that it very much does not and could not ever be compatible with human rights on that basis. The technology that UK police use can scan around 300 faces a second. That's the level at which it's operating. That's the level of ultimately mass surveillance in a public place that this is operating at. And for those reasons alone, let alone the other reasons around the chilling effect on freedom of expression, the discriminatory effect, and its lack of effectiveness, for that ultimate reason alone, we think it should never be used in this country.
And particularly within the live facial recognition context, there's a somewhat famous BBC video of one of the Metropolitan Police trials that Big Brother Watch were actually attending, where an individual who decided, this is the question about the proportionality of whether a person can opt out of being involved in facial recognition. An individual was given a heads up that facial recognition is being trialled down the street. He then walked down the street trying to obscure his face because he didn't want to be scanned in some way, which then led to him being detained and questioned. There were subsequently some issues that went around there, but the kind of proportionality aspect of, like, say an individual was just wanting to walk down the street and didn't want to participate in this kind of activity, how is it that you can continue to balance your right to individual liberty in exactly that way? And that video in a stark way shows that it's not an opt-out system when we're talking about live facial recognition.
I just want to stress again that we have a higher bar than just necessity. It has to be strictly necessary. So that's much further up, a harder one to hit. And all throughout the Commissioner's opinion is the stressing of this need for proportionality, but also the need to have a strong legal framework within which to work and help, I suppose, guide the authorities towards that level of necessity. It's about narrowing down the focus. It's using intelligence that the police have to, as I say, narrow the location in which it's being employed, try and reduce the volume of individuals who are being scanned at any time. And it's not wholesale 24/7 surveillance, it's got to be for very short periods. And as I said, every single implementation of it should be going through a data protection impact assessment, part of which has to consider the human rights aspects.
Okay. You've talked about the massive extent of the capture within any use of live facial recognition technology. I think, Dr. MacDonald, earlier you talked about the impracticalities of ever gaining meaningful consent in that respect. I mean, given those aspects, and I understand, Mr. Ferris, you've taken a view that those downsides are insurmountable, and therefore the deployment really is wholly impractical. But who should be tasked with ensuring strict necessity or proportionality? I mean, presumably the view is that it couldn't simply be left to either Police Scotland or individual police forces. Who can make that decision?
It's up to yourselves as members of the legislature to determine exactly what framework.
We're looking for guidance.
Yes, but to determine exactly what framework it is, and can be used, and obviously it could go into statute. But I think the key thing is that any framework, whether it's statutory or a non-statutory code of practice, has to be developed in conjunction with all key players. And in key players, I'm talking about the police authorities, I'm talking about us as the data protection regulator, but also with colleagues in civil society, such as Big Brother Watch and the Open Rights Foundation, so that we get a proper representation of arguments from all sides of the debate, and come to some consensus. I don't think either of us are going to get exactly what we want, but we can certainly find areas of common ground.
Mr. Ferris?
I think it's worth saying that the way not to do it has been what's happened in England and Wales. The fact that police forces have been given the power, or basically, a free-for-all to do what they want with their technology. For the first at least 18 months, the Home Office, when asked, said that it was a matter for the police. MPs, the Minister for Policing, fielding questions on it, admitted that there was no legal basis for this technology. That's on the record, and yet the police were able to kind of push ahead with the use of it. The Biometrics Commissioner, the Surveillance Camera Commissioner, and even the Information Commissioner, for a time, all stated or said that it was not clear which of the many commissioners with their different remits had ultimate oversight over this technology. So as a result, it basically flew not under the radar, because it was known, and we and others were trying to talk about it, but it flew under the radar of effective oversight. Whilst we don't believe that it should ever be used, I think the way to reach that would be to have a really, really serious human rights analysis of the threat of this technology to human rights and to civil liberties. How that's done, I'm not sure.
So, Makushi, I mean, do you have a view on whether or not, within a human rights perspective, given all that we know about the way in which the technology is deployed, that it can be compliant with human rights?
I think in Scotland, certainly, because we have had the background of the debate around the Scottish Biometrics Commissioner Bill, and a lot of expert advice coming out of that. That would seem to me to be the right place and the right model, a strict code of conduct with some enforcement powers to allow a Biometrics Commissioner to put in place rules and regulations around the use of such technologies, and also to carry out the consulting, the public engagement role that Mr. MacDonald's talking about, because it's absolutely correct. Operationally, the police would like to take these decisions, but they need to do so within the framework that the Parliament set as a tone for acceptability and accountability. I certainly have my reservations, and as the technology currently stands, there is unfortunately far too much evidence that of its failings as opposed to evidence of its real usefulness. However, that is a proportionality assessment that really should be, I think Dr. MacDonald said, should be handled by the Parliament. They should decide where that power sits, and I mean, through this process, that's part of the process. But ultimately, it will have to sit quite high in the public consciousness, and I don't see anywhere else apart from the Parliament to put that.
Thank you for the hospital pass.
Thank you. James.
Okay, thank you, Convener. So throughout the session, there's been almost an ongoing discussion about the legal basis for the use of live facial recognition technology, and whether there is a proper legal basis, or what could be done to establish a proper legal basis, and also whether the use of this technology is proportionate or not. To date, Police Scotland haven't used it. Do you think they should put on hold using this technology until there's a clear understanding and a clear consensus on the legal basis and the proportionality around using it?
One of the key requirements under the GDPR is that whenever personal data is likely to be processed, that a data protection impact assessment should be considered, particularly when the nature of the information is so sensitive as we have here. There's also a requirement that if in undertaking the assessment, the data controller, the organisation, in this case Police Scotland, identify risks that cannot be mitigated, risks to the rights and freedoms of individuals that cannot be mitigated, then they're required to come and consult with us. So, you know, that's one step. If they can convince us that they've done that and that they have the legal basis, and I understand that they are suggesting that their very broad one on the Police and Fire Reform Act to prevent and detect crime may be appropriate. That's what they're saying. And they come up with suitable mitigations to protect the rights of individuals, then that's fine. If they don't, we can take action to actually prevent them from going ahead. So I wouldn't like to say a categorical yes or no in response to your question. It depends, but we would certainly be, or should be, fully engaged with them. They should be coming as direct consultee, not part of a public consultation, but absolutely directly. They're required to do that under law, and we would develop and discuss with them.
I think there's such a huge weight of evidence against the use of this technology, some of which has been heard, some of which I'm sure that the committee has read in other places, that it certainly should not be used at this moment in time, at the very least, and we believe it should never be used. That live facial recognition technology should never be used by police in this country.
I mean, if we look down the lists of institutions such as the Science and Technology Committee, other MPs, civil society organisations, other regulators that have raised concerns about the continued rollout or use of facial recognition, it seems kind of self-evident that it would be foolish for Police Scotland to pursue this without clarifying what they mean by it. And I guess we should also be clear about if we're talking about live facial recognition or if we're talking about post-event facial recognition where you're capturing data and after the fact and are trying to work it out. But at this stage, from Open Rights Group's perspective, we are of the opinion with Big Brother Watch and a long list of others that a moratorium on facial recognition is what is absolutely necessary and would raise a highly sceptical eyebrow towards even further down the line.
Yes, I'd agree a moratorium would be appropriate. Outside this committee's work with digital triage devices, cyber kiosks, for those of us who know, what happened there was Police Scotland did proceed with technology without doing all the impact assessments, etc. And then, you know, that has delayed things for, I think, about 18 months currently. That process is averted simply by doing all the homework first, and I think that would be appropriate now as it was then. And I mean, by the fact that they haven't proceeded to roll out without hearing from other people, seems that they're minded to be the same way. They are holding off until more is known.
Okay, thank you.
Okay, thank you for that. Rona.
Thank you, convener. Good afternoon, panel. I'd like to touch on some parts that have been already spoken about the accuracy and reliability of the technology. It's been suggested that the use of facial recognition can be subject to a lot of issues such as racial and gender bias. And I wonder if you think there should be much more rigorous technical testing of the equipment and how much that concerns you, the fact that, you know, already it's been picked up that it's far from accurate in many cases.
It's a very serious concern that this technology has shown not just to be ineffective. Our original publications around its ineffectiveness were taken from Freedom of Information requests to the police, which found that the Metropolitan Police's technology was 98% inaccurate, whilst South Wales Police's use of the technology was 91% inaccurate. That was in 2017, and we've not seen evidence to suggest that that has significantly changed. An independent report into the Metropolitan Police's use said that it was around 81%, but this is an incredibly inaccurate technology which misidentifies people at much higher rates than it identifies people. When it comes to the discrimination against people of colour and women, that is something which has been found in multiple academic studies. Admittedly, the technology being used by UK police has not been tested. The police have refused to put it through that testing. They've refused our requests to publish any reports of their internal review and testing. A few months ago, a member of the Metropolitan Police who was leading the implementation of their technology admitted that they were aware of a significant gender bias, but so far have not told us what steps they've taken to use it. It's worth saying that whilst it is extremely serious that this technology has those elements of discrimination and bias, even if they weren't present, we don't think that it would be compatible with human rights. But notwithstanding that, the fact that it has that discrimination bias means that it should just on those grounds alone should be enough to disqualify its use.
Okay. Anyone else?
It's a really pertinent question as well, but the bit to bear in mind is great that we're trying to embed this debate within Scotland and what we'd want to see in Scottish society. But the thing to keep in mind is that if any facial recognition technology is more than likely going to come from a commercial provider, which will have trained their system on some number of data sets. And it's actually the problem begins in that lab there, where they decide on this particular data set with these particular people, and the biases come out of that. And it's, from what I understand, almost impossible to walk back from that. So we may try and have a discussion about what is an accurate level and what we want to look at, but it may A, never be achievable. It may not matter either from a human rights compliance perspective. But we're also essentially relying on another organization's ethics in their decisions that they've taken in the development of their technology to determine whether or not it's ethical, accurate, or encoded with the biases that we've seen so far. And that's a really important thing to bear in mind, that we're not in a kind of vacuum or a silo here. We are relying on other decisions taken by other people that may not be in the control of Scottish society.
Yeah. Yes.
Taking the evidence that's been given as read, I think there is ample evidence of the failings in the technology. I think that should give rise to concerns about how Police Scotland use their funding. If Police Scotland were to invest in technology that had this level of failure rate, I think there would be rightly a public outcry, because it's not it's hardly effective, hardly efficient. And when you are talking about necessity and proportionality, we must think about these things in a budgeting sense. When public bodies are accounting and budgeting, they must have these things in mind, because this is a vast amount of money to spend, which could easily be spent on something else that could be more viable, more useful, and have a proven efficacy rate. Certainly more rigorous testing, but also within the process of developing these technologies, a more considered view towards how they will be audited, and a more of a desire to see them audited, more of a desire to say, look, here's a trail, and here's how we've tested it, and here's how we can show it will work or not work, and be willing to accept when things don't work that they haven't worked, and we must go back to our values.
If I could just give an example of of how this technology can affect people in a very tangible way, because I appreciate that something like this can often be a bit intangible. At a deployment by the Metropolitan Police in East London of live facial recognition technology, where we were watching, observing, a 14-year-old black schoolboy was stopped by plainclothes officers after he walked past the van where the camera was located. He was pulled onto a side street by 4 plainclothes officers who asked him what he was doing there. He was on his way home from school. He was wearing school uniform. He was questioned. He was asked for his phone. He was fingerprinted. And it was only after they checked his fingerprints against the person they believed he was that they realised he was just an innocent schoolboy walking home. And that's just one example of how this technology, this oppressive and authoritarian technology, can can very seriously impact people on the ground. An innocent 14-year-old boy walking home from school who was swooped by police who believed that he was an individual on their watch list because the technology had said that's who he was, and who was subjected to a pretty harrowing ordeal.
There's also the aspect of the human operator's sort of relationship connection with the technology, and that one person's perception of an image might be different from another. Do you think that could ever be resolved, even if the technology was more advanced and more accurate? Do you think there's still an element of risk there, depending on, when you're relying on someone's judgment or perception?
Go ahead.
I mean, just based on that one example, I think that it shows that there was this match was made by the technology. It was inaccurate, and yet between the officers in the van who'd looked at that and said, well, it looks like him, it must be him, you should stop him. There was not only was there a failing by the technology, there was a failing by the officers as well. I mean, the two things are linked. The reason why the technology is inaccurate and biased is because, as has been mentioned, the data sets upon which they are trained are often inaccurate, and so not inaccurate, they are biased. They are data sets which contain often majority white men, which is why the technology shows such a high level of misidentifications of people who aren't white or people who aren't men, because that technology just simply isn't able to recognize them. But yes, so there's very clearly an issue at both levels.
The Commissioner, in her opinion, does raise concerns about the effectiveness of the technology, and where there are groups which have disproportionately high mismatches. Her view is that it should only the technology should only be deployed where there's a low tolerance. Now, the low tolerance is obviously based on these biased data sets, but they have to work on the basis of the best evidence that they have. But crucially, both in terms of the situations where they deploy the live facial recognition, they should be reviewing the outcomes as time goes on. So we can look at how more effective it becomes, and effectiveness isn't just about the ratio of mismatches to images, but also the final outcome, whether somebody has been proven guilty following their identification. But it's an ongoing educational issue, and it's an ongoing technological, statistical issue. Continuous improvement.
Could you maybe just explain what you mean by low tolerance? I'm not following that.
In terms of how many, the proportion of mismatches, and we've already identified that people of colour and females have a disproportionately high level of mismatches because the data sets are based on white males.
Okay, thank you. Thank you, Convener.
I wonder, before I bring in some other members, Mr. Rice, can I pick up on a point you said there, because in stressing my lack of technical know-how, which is important in this case, because not everyone in the community is an IT expert, this seems to me to revolve around a situation which you touched on. It's not the police themselves who will devise this equipment. These are commercial operators who will make bits of equipment, and just as we could all have different mobile phone providers telling us the various good things their phone does and not highlighting any negative things they do, this would seem to be a public procurement issue were the police to go ahead. How can they make a judgment on this? We've heard previously that of the models used in other forces, they were in a league table, very well down the league table in terms of efficiency. Now, I'm not necessarily commending the acquisition of bits of equipment, but were the police to do that, how would they go around that? Because any manufacturer will be very well aware that Police Scotland have laid out a long-term IT strategy in which they've mentioned this equipment. So they're very much in the frame for buying as far as these people will be concerned. What parameters should be set? Because the human rights impact doesn't seem to be something that a manufacturer would necessarily be considering.
Yeah, and well, from my experience of previous to Open Rights Group and working in working at the understanding to work in the private surveillance industry, they often think about sales rather than thinking about the rights impacts. We have to think about this sequentially, I would imagine. The thing that the worst case scenario is something that we saw with the digital triage device purchase, where procurement was made at a rate before any kind of assessment of its efficacy, human rights impact, data protection compliance, and then this equipment sat there. It was and it has sat and continues to sit there for a number of months. So the point I'm trying to make, I guess, is that if you were to want to, despite the fact that there's an intention, that intention should not manifest itself in any procurement until the wider public debate has taken place, that a lawful basis has been established, that that the specific terms under which a technology like this, and bearing in mind our continued reluctance to accept live facial recognition would be necessary in Scotland. I'm talking about potentially other forms. But that still needs to be defined in law before it becomes a matter for technology procurement. And we really have to reflect on the digital triage devices in the cyber kiosk debate about how that should look in terms of the sequence under which the public, MSPs and civil society organisations and wider groups would be able to feed into that before we even begin to think about what procurement looks like.
Mr. McCusher.
If I may add, just to reinforce what one of your earlier submitters, Dr. Bobak, said, there's, I believe, a joint project between Stirling University and Imperial, perhaps another university, where they are developing this technology with government funding. With that sort of a public process for actually developing the technology, you could build in the human rights concerns and the human rights solutions at an early stage and develop the technology along those lines. To be honest, if you can't develop the technology with those things in place, that's a really good argument for not using it.
Yes, Mr. Ferris.
From our other work around new uses of technology and information and human rights concerns, what we often see is technology is bought, and then whichever authority is attempting to use it, they often try to fit the framework around that technology rather than having those standards, high standards of human rights or data protection, whatever you're talking about, in place first, and then looking to procure technology which fits those standards. And it's often done the wrong way around.
I think if I return to comments right at the start on the retention of custody images, we're coming to almost the same thing, in that now there is a requirement to have this privacy by design built into the whole process, and that includes where you're going to be processing personal images, that includes issues like procurement, and you should ensure that the equipment that's being used will allow deletion, will allow compliance, and it's got to be much further up people's agenda.
Okay, thank you very much. Margaret.
Yeah, good afternoon, panel. If I could just drill down a little bit more on the public consent, public engagement issue, and it's clear from what we've heard today that you don't think this has been sufficient to explain the purpose of using live facial recognition in open spaces. So it's almost a rhetorical question, but just for the record, do you think that it should be a prerequisite to carry out community privacy and equality impact assessments prior to the deployment of this technology in open spaces?
Yeah, absolutely. Yeah.
Absolutely. Although I don't think that those on their own are enough or sufficient enough to give permission to the use of this technology.
I suppose that's my next question, but if I hear it from everyone, what else can be done, if anything? Dr. MacDonald?
Well, I mean, as I've already explained, there is an absolute statutory duty to do the privacy side of that, and I think maybe this is one question that we can actually all concur in relation to these assessments. I can only really comment on the DP side. It does include public engagement element because people have to be aware of what's happening, aware of what can go wrong with the technology, and there probably is a much bigger, wider public debate that has to be had.
Anyone else? Yes,
Certainly, again, Dr. McDonald's correct. I quite agree. The only other thing I would add is, even where the public are informed, and perhaps surveys are taken, polls are taken, it's quite important that we remember that there must be a human rights-based framework around this use, even if the public were to be seen to be somehow signalling support to a degree for this technology. If it wasn't human rights compliant, that shouldn't be a whitewash. It's not a competition between a democratic mandate and a human rights-based framework. The two have to go hand in hand.
I think that's going back to the individual circumstances again, must be looked at. It can't be a blanket.
Absolutely.
Okay. Anything else you'd like to add on the public consent and public? Okay, that's helpful. Jenny?
Jenny, thank you.
Convener. Good morning to the panel. Following up from Margaret's line of questioning there, and I guess referring back to some of the answers to Liam MacArthur earlier, we know that facial recognition has been used, at political events previously, and on campaign marches and rallies. And I wonder what impact you think that might have on democracy, as people think they might be being watched for things which are, entirely legal and legitimate. Do you think facial recognition is a danger for democracy?
No, go.
I'll just point you to the submission of Dr. Aston, who submitted to this inquiry. She said there's a dearth of information around the impact of increasingly technologically mediated interactions on police legitimacy, and that's something we have to be very concerned of. We have a culture of policing by consent in this country. If we start making more and more interactions through cameras and websites and all the rest of that, we don't really know what the long-term impact that is, and if we're going to risk that, there must be, again, very important proportionality assessment as to why we would do things as opposed to the way we have done them, where it's been shown to work. The purpose of policing has to be also, as well as detecting and fighting crime, to enhance safety and well-being. That's within the legislation. So policing must meet those requirements as well as simply what they want to do, which is to detect crime.
It can certainly have a very serious impact, and it's well established that surveillance can have a very serious impact on people's willingness or ability to exercise free expression, not least and this is most pertinent in the use of live facial recognition at public events like the democratic, or the peaceful democratic protest that it was used at in South Wales. I think that it certainly has a chilling effect. Our legal challenge that we brought alongside Baroness Jenny Jones, who is a long-standing campaigner for many issues, not least the environment. One of her many arguments was that it would severely impact her ability to go to political events, to meet people as part of her parliamentary work, but also as part of her activism, and that she would be extremely concerned that other people would be, for example, whistleblowers would be less willing to meet with her and discuss serious and important disclosure and other issues if, as she is concerned, she might be subject, or her work or areas of democratic work might be subject to this technology.
And there's been some strong work in terms of the chilling effect of kind of online surveillance. So not even the surveillance that is necessarily overtly proven, but something where a person feels that there's a notion of being watched, changes people's activities and behaviours. The PEN International have done very strong work on that. And facial recognition carries very similar hallmarks, that if you feel as though or if you have an understanding that facial recognition may be being used, but it's on a kind of nondescript looking camera, it changes the perception of how a person, even if it isn't being used, will act in terms of potentially affecting their rights to freedom of assembly and association and freedom of expression. So it's very much tied in terms of other forms of surveillance, that chilling effect and that harm to democracy could very much be real.
As you'll be aware, we've produced a report following the European referendum on the abuse of data, selling of personal data, and how it disrupts democracy. And we'd have similar fears if facial recognition technology was being used in such ways as to have that chilling effect. Again, it comes down to the absolute specification of when to deploy, and just doing a phishing exercise and identifying for future action by some individuals in it would be entirely unacceptable and no doubt in breach of people's Article 6 rights.
Yeah. Thank you very much. You'll be aware, obviously, we're considering a bill at the moment on introducing a Scottish Biometrics Commissioner, and I wonder, therefore, if you think that live facial recognition and public confidence in its use should be a priority for the Commissioner in that role.
Yeah, that it's clearly a hot topic issue, an issue of real public concern. From any polling that's been done, this is an area that the public really do have an instinctual reaction to, and for the role of the nascent Scottish Biometrics Commissioner, seeking to establish public understanding, trust and confidence in the use of biometrics in policing context will be vital, and facial recognition is probably at the top of that list.
Yeah. Thank you.
The England and Wales Biometrics Commissioner has made several comments over the last few years around the use of live facial recognition, but one thing he doesn't have is any power to do anything about it. And I don't know the full extent of what may be or may not be proposed in the introduction of a Scottish Biometrics Commissioner and what powers they may or may not have. But I think it's worth including in the conversation that just because this technology is available and other people are using it, that does not mean that it necessarily should be used. And that's something which has been, I think, lacking from the conversation in England and Wales, that just because this technology exists, it must therefore be used in some way, and it must therefore be regulated in some way. But I think certainly that it should be within the remit of an authority to say that actually, no, we don't want this technology, we don't think it should be used for all the reasons that have been well discussed over the last hour.
Thank you.
Yes.
With regard to Scottish Biometrics Commissioner, I'd point to the work of the independent advisory group who researched the role, and they clearly had facial recognition within their sites. They cited it as an area of concern. I wouldn't necessarily say it should be a priority. I think all technologies, emerging technologies, would certainly be a priority. I think the priority is chiefly to establish a legal framework, a code of conduct that that gives guidance, that gives certainty, that gives transparency to how agencies are directed, whether they are public or private. And obviously there has been some gap between what's been said before the committees about the scope of the Biometrics Commissioner, particularly in regard to powers and accountability. I think it's very important that the Biometrics Commissioner is positioned in a way that whatever they do, whatever technology they're looking at, whether it's facial recognition, drones, cyber kiosks, they are in a position to lay consistent, clear guidance down, and that really is a priority for the Commissioner.
I think I should just add the note of caution that, of course, there's a potential overlap between our work in regulating the data protection side of things and the Scottish Biometrics Commissioner's work. I mean, that's clearly laid out in the bill that there is that distinction. We still have the responsibility for enforcing people's rights. The situation south of the border is, of course, is that they've also got the surveillance camera commissioner, and I think the more commissioners that you have in a sort of general area, the more opportunity there is for confusion. So I would say yes, include it within the biometric commissioner's remit, but just bear in mind that we do have a statutory role as the devolved, as the reserved regulator for data protection.
Thank you.
Thank you. And just to say that the Justice Committee is picking up on these issues. Thank you. Fulton.
Thanks, Convener, and good afternoon, panel. I was going to ask you about the issue of the technological developments in this area, being driven by private companies, and I know that the Convener has already started to explore that, particularly with Matthew Rice, but I wonder if any of the other panel members that didn't get a chance earlier have got any concerns about the possible blurring of boundaries here between the private companies and the responsibilities of the police, and particularly in relation to human rights concerns. And as I say, I know we've touched on this already.
There's certainly been across England and Wales a blurring of boundaries between the police and private companies, whilst the police in different police forces have been using it since 2015. It only came to, I think, widespread attention that a number of private companies were using this technology around August this year. We did an investigation to try and find this find this out. And when we initially sent freedom of information requests in 2017 and 18, we were told by a number of police forces that they weren't working in partnership with any external companies. It then came to light in August of this year that the Metropolitan Police and British Transport Police had been sharing images and working with the King's Cross estate in central London, who were using this technology. There are a number of other large public spaces. There was a shopping centre in Sheffield, a music venue in South Wales. I mean, there's a list. There's a number of places which came out that were using this technology in conjunction with various police forces, all of whom had told us a year or to 18 months previously that they weren't working in conjunction with any external companies. So I guess that shows that there's very much a lack of transparency, a lack of knowledge, potentially that it's been deliberate. There's been a deliberate element of secrecy to it, but certainly that there is this there has been close partnerships with private companies using this technology and the police, all of which benefits private companies which are selling this technology, whether that's to public authorities or to other private companies which wish to use it in their own spaces.
So what do you think the implications of that might be for the person on the street?
Sorry?
The implications of such an arrangement, what do you think that might be for individuals, and particularly, as you say, that there might have been an element of secrecy? Why do you think that there would have been secrecy? Why would there been any need to be secrecy?
Well, I think if as has been well established there, the police have been using it in a way that is that infringes on human rights, with all the supposed, lack of, but supposed safeguards around its use. The fact that private companies are able to use this not only, effectively secretly, but without being held to the same high standards as public authorities is obviously extremely concerning. I mean, it's difficult to speak at length without knowing what's going on, because that is one of the serious problems. We don't know who's using this we don't know comprehensively who's using this technology and where. We have a few reports here and there from where organizations or journalists have been able to uncover it, but it's just difficult to say because we don't know. One example, in King's Cross in central London, we know that the Metropolitan Police and British Transport Police shared images with the King's Cross estate. We don't know if if anyone was stopped or removed from the area, but there has been an indication that it was used to combat antisocial behaviour, although we also know that some of the images that were shared weren't of people who were actually wanted for any crimes. So it was people who had criminal records but who were not currently wanted for any crimes, which suggests a very kind of clear expanding of the use of this technology if it's just being used to monitor and track and ultimately control the movements of people who are or may be known to the police, but who aren't actually, who haven't actually done anything wrong in the present moment.
And so moving on from that evidence that you've given there, do you think that any legal framework should explicitly refer to those who have got responsibility for capturing, storing and deleting images captured by live facial recognition? Would that be your view in any framework?
Well, I mean, yeah, I think you'd have to. Yes, I think you'd need to be able to reflect that this technology does not just exist in the policing context or used by police. So even in a very specific and Scottish context, we know that Glasgow City Council have a series of CCTV cameras. They've replied and responded to this consultation, where they seek to explain what the relationship is between when they use it versus when Police Scotland uses it. And it does seem like there is some ad hoc kind of organisation. They seem to recognise that for it to move from the Glasgow City Council or a public authority into a policing context would place it very much in a different legal framework and would require a separate and additional basis for using it, which is good. But I think it should also be straightened out in clear primary legislation about how any kind of information sharing or even kind of like use of the technology directly, so not just an output from the technology, but say Police Scotland being able to view the monitors or view the technology as and when it's being used, which is slightly different to sharing the information derived from that technology. All of that needs to be out on and clearly articulated under law. And what it means for the individual is that it creates a lack of foreseeability about what are the boundaries of interference, or what are the boundaries of autonomy when you're walking down a street in Glasgow, or when you're walking along in your housing association, for instance, and the images that are being collected, where can they end up? And ultimately, we need to provide the public with clarity about what happens when you walk down the street. It seems strange that that might be the burden that you have to do now, is explain to the public what happens when you walk down the street. But the more that we see these technologies kind of move into other sectors, that is what we're beginning to have to kind of reckon with.
I'd say there's probably two separate strands here. There's the strand where you have private organizations acting as proxies for public authorities. So whether they're gathering the data at the specific behest of a public authority, or they're gathering it whether it's reasonably foreseeable that it will be used by public authority, they should have in mind exactly the same human rights standards. In fact, that they should flow from the legislation, from Article 6 of the Human Rights Act. And they should be bound by that, and they should comply with the same requirements for assessments and evaluation. The other strand is private organisations themselves simply using it for their own purposes, whatever they may be. And I understand, and I'm not entirely a data protection expert, I understand that there is some of this that would fall within the remit of the Information Commission at present, because this is data that's been collected, processed, and whether it's images or not, it is still data, and it's, it must be governed by the same rules about being strictly necessary and how they use it. And that's perhaps falls out with the human rights argument. But there's perhaps a call then for the Scottish Government, as Matthew said, a statement of values, where do our boundaries sit as a society to say any organisation using biometric data, specifically because of the nature of biometric data, should be held to a higher standard. It has the capacity to intrude so severely on people's lives that even private organisations should be treated to a higher standard than they normally would.
Whilst private companies may of course not have the same powers as public authorities such as the police, they're also much more likely to have a lower threshold to be able to use what powers they have. For example, people who may have been, who may have shoplifted in the past, being barred via live facial recognition from entering shopping centres, or people who have, been seen to commit or antisocial behaviour, being barred from public spaces, or even public-private spaces. And that is, I think, just as kind of chilling and authoritarian, barring people from just going to the shops because of potentially a misdemeanor from some time before. And for what it's worth, the declaration that was agreed on by 26 rights groups and a number of leading parliamentarians did include not just the use of live facial recognition by police, but also by private companies. And that declaration for a moratorium included both police and private companies.
From our perspective, in terms of the relationship between the police and private providers, our concerns again would be how it fits in with the general data protection framework. There needs to be a clear contract between the two parties, particularly where one is acting as a processor on behalf of the police. That contract should refer to the usual things about security, etc. And one of the perhaps benefits of the GDPR is that where previously any breaches by a processor were deemed to be the responsibility of the original controller, and so any regulatory action was focused, say, to Police Scotland, even if one of their controllers had been in breach. Under the new framework, the processor themselves could have regulatory action taken, and that provides a spur to them to make sure that they comply. As Griff has said, the situation is slightly different where the private sector are doing the processing themselves. The requirements for strict necessity that I was talking about are under Part 3 of the Data Protection Act of 2018, which is all to do with processing for law enforcement purposes by competent authorities, of which the police is one, the councils are in certain cases, but the private sector themselves have lower thresholds, as Griff says.
Okay, thanks.
Liam, were you?
Just, conscious I'm matching you stride for stride in exposing my lack of insight into the technology here, but Matthew Rice, earlier you mentioned the issue around use of CCTV, and I suppose there'll be deployment of that in a purely in a sense to discourage and being sort of preemptive in that sense. But the technology appears to be used and supports cases then being brought without the same level of concerns there are around the reliability of live facial recognition. I mean, is there any reason why that should be the case?
Could you?
Well, that you're using CCTV evidence to demonstrate an individual was in a location at a particular time to support a criminal case or whatever it is through the legal process. So presumably there seems to be an acceptance of the reliability of that sort of evidence that from the figures you've suggested in terms of the reliability of live facial recognition just isn't there with that technology. Is there a reason for that?
I mean, this is me having to dip into my Scottish criminal law seminars from years ago, but it will involve a series of other corroborating evidence, right? So person X was in a certain area. We know this. They were wearing these clothes. The problem that we're seeing with live facial recognition is that it is essentially it is an analysis of an individual's face and facial features to a mathematical point at which they say this is quite like that individual. Right, so it doesn't have all these necessarily kind of corroborating features that are around it. And when it comes into the context that kind of Griff was putting in terms of when a person is immediately detained, it's quite different to when a person is prosecuted. When you've got prosecuted, you've made a series of decisions about evidence that is immediately available and likelihood of prosecution. Whereas detaining a 14-year-old black child because he shows up and he matches mathematically a kind of a dodgy data set or a dodgy algorithm, that's the kind of stark contrast that we're facing.
Okay, thank you very much indeed for your evidence. That's been extremely helpful to us, and we'll suspend very briefly to allow the members, the witnesses to leave, and then we'll reconvene in public session. So thank you very much. Briefly suspend. Thank you. Okay, thank you very much indeed, everyone. Our next item of business is consideration of the recent peer review undertaken by the Metropolitan Police Service of Police Scotland's Anti-Corruption Unit's investigation of the former Scottish Crime and Drug Enforcement Agency. Now, I refer members to paper 4, which is a note from the clerk, and paper 5, which is a private paper. And as members will be aware, there are currently live court proceedings in relation to this case, so I would draw members' attention to Standing Orders Rule 7.5 on sub judice issues, which I'm sure you're word perfect, and ask them to be mindful of this when making any remarks on the record, please. And I would invite views on the recent consideration of the Metropolitan Police Service's peer review. Liam?
Thanks, Convener. I think there's a suggestion that the subcommittee, or you on behalf of the subcommittee, write to the SPA asking for clarification as to whether the consideration of the issue is now concluded. There's probably a a number of detailed questions we would want to fold into that request, but that seems to me a sensible way of proceeding at this stage.
Okay, thank you. Anyone else?
Yeah, I think we agree.
Well, thank you very much indeed. Well, if members are agreeable, that's what we would do. We will write to the SPP to seek clarification on whether the issue is concluded, and there are a range of questions, and of course, as ever, this will be published on our website. And we now move into, that concludes the public part of today's meeting, and we move into private session. So I'll suspend very briefly. Thank you.